Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, have you ever read a story, heard a story, and the minute you're done hearing it, you're just like, no, that doesn't pass the smell test at all? Well, that's exactly the reaction I had during lunch today when I was just geeking out on some U.S. news. Heard a story about an incident involving Secret Service back in Washington, D.C., those that are tasked with protecting President Joe Biden's granddaughter, and a shooting that took place about an incident involving a car. Now, I'm going to connect all the dots for you here, but I tell you, there's a lot of details that don't make sense about it, and if they are in fact true, well, then somebody probably is facing criminal charges, and it might not be the people that you think. So today, let's spend a few minutes, let's apply the law, and let's geek out and talk about why the Secret Service story does not pass the smell test. Okay, Dateline, Sunday evening, November 12th, Washington, D.C. Metro Police and the Secret Service are now investigating an incident which took place in the Georgetown neighborhood. Apparently, the Secret Service agents tasked with protecting Naomi Biden, which is President Biden's granddaughter, discovered three individuals attempting to break into an unoccupied government vehicle. Let me say that again. They found three individuals that were attempting to break into an unoccupied government vehicle. They encountered those individuals, and at some point, Secret Service discharged a firearm. There is at least one agent now who admitted to discharging his firearm. He also admitted that he struck nobody. So glad to see that all that time in the range is paying off for the Secret Service. Now, the Secret Service also stated that the protectee, that is Miss Biden, was never in any danger whatsoever. So what we have here is a potential break-in of a car that then has Secret Service using lethal force, and we know the car was unoccupied, so nobody was in the car that was going to be an imminent threat of death or serious bodily injury, and that the protectee, Miss Biden, was never in any danger. So if that's the case, what would happen if one of you just looked out in your driveway tonight and saw someone trying to break into your car, or saw someone trying to cut out your catalytic converter, and you just went out there guns a-blazing? Well, depending on the jurisdiction you're in all likelihood, you're going to be charged with a crime. Why is that? Well, let's go back through our general rules of self-defense law. Remember, anytime we're going to use force to defend ourselves, the force we use has to be, one, necessary, two, has to be reasonable, both objectively and subjectively, and three, has to be proportional. Remember, we don't get to use lethal force unless we are an imminent threat of death or serious bodily injury, somebody else in our presence is an imminent threat of death or serious bodily injury, a felony is being committed upon our person, or a felony is being committed inside our home. Now, there is one scenario where if perhaps the Secret Service agents went to confront these individuals, and the individuals then turned their aggression towards the Secret Service, and at one point placed one of the officers in imminent threat of death or serious bodily injury, then the discharge of the weapon is lawful. But there is absolutely nothing in any of the reports, and I have scoured now multiple media outlets trying to get as much details as I can, there is absolutely no mention of any kind of activity such as that. Now, listen, I did have an opportunity to geek out on District of Columbia self-defense law, and I did so because I knew that their gun laws were absolutely atrocious, and I had a feeling that their self-defense laws would be the same. And guess what? They did not disappoint. Now, unlike many other jurisdictions that actually have self-defense statutes, in Washington, D.C., you actually got to take a look at the jury instructions. That is, what instructions would a jury be given if you were raising the claim of self-defense? The self-defense instructions in the District of Columbia read as follows. A person is justified in using reasonable force to protect their property from theft or misuse when they reasonably believe that their property is in immediate danger of an unlawful taking or misuse, and that the use of such force is necessary to avoid the danger. And the District of Columbia jury instruction further states, if a person reasonably believes that someone has unlawfully taken their property, they may use reasonable non-deadly force to repossess the property. but they must act immediately after the taking has occurred or in hot pursuit of the person who has taken the property. If time has elapsed, a person may not use force in repossessing the property. But those instructions go to when someone is actually taking the property. And what's happening here is the property is being vandalized. Now, again, I believe in all likelihood that some type of reasonable force is permitted to protect property from unlawful damage. However, and I can assure you this is the case in the District of Columbia, the use of lethal force is absolutely positively not authorized no matter who you are or who you work for. But then there's also this extra little wrinkle, which is the District of Columbia actually do not have a no duty to retreat or a castle doctrine or a stand your ground. Now, they haven't said that there's absolutely a total duty to retreat, but they have instructed jurors that you must consider the ability to retreat or flee or the imminent danger of what's occurring in determining whether or not the use of force was reasonable. In fact, I found at least 3 cases that specifically state that a jury is supposed to consider the ability to flee or avoid conflict when determining the reasonableness of self-defense force. So the bottom line is that if Secret Service found 3 people breaking into a government car, at no point was any human being ever in imminent threat of serious bodily injury or death, and therefore the use of lethal force, that is the discharge of the firearm, would absolutely positively be unlawful. Now, unless they can establish that we were keeping the nuclear codes inside that car, I doubt it. That we were keeping Jeffrey Epstein's island guest list in that car, I doubt that. There really is no way of establishing that anything inside that vehicle would have then created an imminent risk of safety to anybody else. So the Secret Service here ultimately has a little bit of explaining to do. If they are going to act in accordance with District of Columbia laws, it would appear that one of their agents here has greatly overexceeded his permissible use of force. Listen, there will obviously be more developments. If we think it's worthy of another video, we will do so. In the meantime, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.